because I think it's utterly immoral to tell someone else what they have to put into their body. I mean, if we can't agree that I get to direct my own medical treatment, then, I mean, we don't live in a free country. And so for me, that's absolute. Nobody gets to tell me what to do. Okay, if I have mental impairment in some way, or I'm a threat to myself or to others, then I could understand. But that's very, very rare, right? For the vast majority of people, we get to choose. And this is exactly how I got the Medical Freedom Act passed in Idaho this spring. But basically, I just think it's a moral issue. Can you imagine someone telling you, well, this might injure you, because this is the truth. This might injure you, but we're going to force you to do it because you know why? We think it's more important that the community be protected, even if there's no public health justification. So what they're saying is, even if the shot doesn't have a public health justification, we should still be able to force you to take medical interventions if someone says it's for the public good. And they even went so far as to argue that as long as it benefited the individual, that was sufficient.
But what if it didn't benefit the individual?
They're saying it suppresses symptoms, and if it helps reduce symptoms or
So now you can force therapeutics? I mean,
that's
that's
what they're
effectively what they're saying.
yeah. Yeah. The problem is, as immoral as Jacobson is, so it says that the state owns you and can tell you what to do. As immoral as I believe that is, it was in 1905. You and I couldn't vote. And they're using something from that period. But there's another piece. Justice Harlan, who wrote Jacobson, who wrote the majority opinion in Jacobson, he said that none of us has the expectation of absolute liberty at all times. And that's true. That's absolutely true. But it's a big leap from liberty, meaning the freedom to go and move about and do what I want, to being required to be injected with a product that could injure or kill you in order to live a normal life. That's a conflation of liberty and bodily autonomy. And I think it's wrong and it needs to be fixed.
It's unbelievable. I mean, what about the Nuremberg Code? I mean, does that supersede anywhere in this discussion? Does that matter at all? You can't have informed consent if you have someone from the government lying, right? Because that was established. Knowingly lied, misguided the general public. Or, even saying, well, we know it doesn't stop the spread, so it's not necessarily a vaccine. And we know that we've made mistakes in the past and we know it harms people, but we're going to continue lying. So, I mean, this is such a scary precedent on so many levels because it excuses effectively government criminal fraud, malfeasance. It encourages our government officials to lie, which I see in other areas too, but it's such bad precedent all around. And so the judge in the case who wrote this opinion, and then the judges that agreed, who was the judge who wrote the opposing opinion?
His name is Judge Bennett, and if you go to our website, you can actually read the opinion, and you can read the ruling, and you can also read my analysis of it. I just rip it to shreds because it is so appalling. I mean, it's staggering. And the other thing that's really interesting is that we had oral argument in front of Judge Bennett and the other 10 judges who were part of the en banc panel, which means a broader panel than just the 3-judge panel that we had a year and a half ago. And we walked out of there elated. It went fantastically well for us. We thought for sure that we had 6 to 8 of those judges on our side. And usually it takes, like I said, a really long time for the Ninth Circuit to rule. And you know what? It only took 3 months, and there wasn't a single concurrence to Judge Bennett's opinion, which I find very odd because they were all arguing in our favor, the vast majority of them, during oral argument. So what happened?
What happened?
I believe it was totally political, and I believe it was completely orchestrated in order to reach a foregone conclusion. They simply could not allow the 3-judge panel, who correctly applied the law with respect to Jacobson. Jacobson did not say that any emergency. It said extreme emergencies, and that there had to be some reasonable connection to public health and safety.
I mean, you've got to appeal it. The Supreme Court's been on an interesting role recently. And I think that this particular Supreme Court, they're going to see this case and they're just going to, I mean, it makes me feel, I went to law school. I'm a barred attorney in the state of California. It makes me want to throw up because it goes against all of the training that and the dignity of the profession and dignity of the law and the reading of the law and trust in the judges. I mean, it makes me scared for our judicial system when judges go so far off interpretations. They don't have the discretion to do that. They have a very specific job to interpret the law and, look at the facts. And I just don't understand how they got it so wrong, how Bennett got it so wrong. And, are these other judges, the concurring judges who refuse to write opinions because what are you going to write that's not going to tarnish your credibility? I mean, that's why they didn't write it, because if they did write concurring opinions, it's going to fully tarnish their ability because what are they going to write?
Exactly.